Inspection of books and records by members. Under Arizona law, owners have a right to see books and records for your association. That's the law. And there's they can see pretty much everything. Okay, so we're not playing hide the ball on books and records requests. A couple of points that you need to know. Number one, when an owner makes a records request, typically they're a disgruntled owner. Okay, you don't typically just get people who love everything that's going on at the association wanting to find out more. You get somebody who's agitated or upset about an issue. They typically make a written request to the association and they ask for certain categories of information. There's certain things that we can withhold from the owners, but it's not much. And if you look up here on the screen, there's 5 areas that we can say, no, you can't have these records. But everything else is fair game. So what are the records they cannot have? Number 1, anything that's privileged between an attorney for the association and the association. So my bills, an opinion letter that I give to the board regarding anything, my status report regarding collection files, all of that the owner is not allowed to see. Anything that's pending in litigation. So if there's a lawsuit that's been filed, we can say you cannot have anything pertaining to that lawsuit that's been filed and is active. Executive session meeting minutes. If they can't be at the executive session, they shouldn't be able to get the minutes after the fact. Personal health, financial records of an individual member of the association, an employee of the association, or a vendor of the association. We don't see this that often. But occasionally we'll have some personal information about an owner in the file, like their bank account or their social security number. Records relating to the job performance of, compensation of, health records of, or specific complaints against an individual employee or a vendor for the association. Be careful on this one, because a lot of our clients will look at this and they'll say, well, that's the management contract. The owner cannot have the management contract because it, outlines what the manager does for our association. It outlines how much we pay the manager or any other vendor. And that's not exactly right. I suppose if you wanted to, you could give them, you have to give your contracts. Your vendor contracts are fair game for an owner to see, okay? What you could do is you could redact or blacken out how much you're paying your vendors on the contract. But I advise against you doing that. Why? Because there's 10 other places they can find that information in your financials. Because they're allowed to see your financial statement. They're allowed to see your budget. They're allowed to see your check register. They're allowed to see canceled checks. They're going to figure it out. So why would we play hide the ball on something that they can find out in another way? And so, I'm all in favor of associations that function at a high level are not associations that are playing hide the ball, okay? There's some things we shouldn't be giving. Like if we're in the middle of a lawsuit with somebody, I definitely do not want you sending my letters to the other side, because I could be saying in the letters, I don't think we have a good case. These are the biggest weaknesses in our case. That would be horrible if that got out to the community. But other things, like the management company contract, I think you should give it. That's my opinion, and I think it's the law. As well. A couple things on inspection of the records. Once the record request comes in, we have 10 business days to provide the records to the owner. So make sure that you keep track of that, what day it comes in. You have 10 business days, and we can charge 15 cents per page for any records that they want to see. We're doing a records request right now with an owner where they have asked for like 20 years of records. I know. And so anyways, what we did right away when the records request came in, I knew there was no way this association could get those records together in 10 business days. So we immediately wrote a letter to the owner saying, due to the high volume of records requested, we are going to need a month to provide these records to you. Another little tip, after you do this for 20 years, you come up with some really good nuggets. This is a good one. Earlier in my career, I once spent an entire Saturday copying documents for this owner. And I had them we have a really large conference room table. I had them on the table. There were like 8,000 documents that the owner requested. and he wanted copies. And then when I told him it was 15 cents per page when he was coming to pick them up, what do you think he did? He walked. He didn't pay. And so a little suggestion is, if you have an owner that's making a very large document request, get that check up front. I can guarantee you, if you're working with me, I'll get the check, because that Saturday is forever ingrained in my mind. So just, keep that in mind. A couple things, if you have somebody that's really a habitual, like I've got a couple of little buddies in associations that are asking for records every other day, don't make it easy on that type of person. Okay, I'm all for, let's provide records to the owners, that are reasonable, under the law. But if you've got somebody who, I'm thinking of one person in particular, who probably when I get back to the office today, he'll have at least 3 more records requests for me. Resist the urge to email that person the records, okay? Make it a little harder for that person, because this person is harassing, basically, the association. So you want to make it, this is how it's going to happen. You're going to have to come down to my office to pick up the records. And it has been a more effective strategy since we've implemented that on that particular person.